Okay, I have Steve Bresnen. You are testifying on behalf of Texas Campaign for Mothers and yourself, and you are for House Bill 44, is that correct?
Yes, Mr. Chairman.
Okay, you may proceed.
Thank you very much. I want to try to briefly hit three quick issues. As always, when I testify, I like to start with actual language in the bill. And on page 2 of the bill, at line 5, the words life-threatening are stricken. And I'm afraid that some people have testified have stopped reading about that point. And that's kind of been a red flag for people. But if you read the rest of the sentence, it says, physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death. That phrase is the same as life-threatening. So we're not taking that out. All we've done as a matter of English, not policy, when you strike the words life-threatening, it makes it clear that there's an or in the middle that is risk of death on the one hand or substantial impairment of major bodily functions on the other. So that's what that's about. The second thing I'd like to address is I'm sorry I didn't get her name, but the lady who proposed an amendment by striking section 14 and inserting a sentence that said medical emergency exception applies to all Texas abortion statutes. The problem is the medical emergency provision applies to the life of the mother and her major bodily functions. That would not address the concern about furnishing the means of. And I believe Mr. Hendrickson was placing it in the statute, in the bill, in what essentially is a medical malpractice provision that I don't think is going to do the work there. If we're wrong, the federal courts are going to decide. The Fifth Circuit Court of Appeals at a minimum, and maybe the United States Supreme Court, are going to decide the issue of whether the 1925 statute is alive or not. I think I can make a credible argument that it's alive, and I don't discount the wisdom or the lawyer, the credentials, the bona fides of the lawyers who argue that it's dead. But one thing I do know is the Fifth Circuit Court at a minimum is going to make that decision. I have no faith that they will hold at the Fifth Circuit that statute is dead. Consequently, we must have an amendment to that statute to protect the life of the mother and her major bodily functions, or this whole bill will not have been effective. Doctors and hospitals will not have had the assurance that they need. Representative Collier, if you'll ask me the question about defenses and exceptions, I'd be happy to answer it.
Thank you.